So we're going to review the request for production of documents, specifically service on a non-party, as well as the request to inspect property. Hopefully, most of this sounds familiar. We did go over it when we went over the request for production of assignment in class on Monday. I know we covered it pretty quickly, so hopefully this will sound familiar, but also just ensure that you do understand these four different documents and the rules that apply. So just going to review the four documents again for a request upon a non-party. Notice of intent to serve subpoena. That is the notice that we send to all the other parties with a copy of the subpoena, letting them know we want to serve this on the non-party and giving them 20 days to object. Subpoena we also draft. This is the document that we will ultimately serve the non-party, asking for certain information to be submitted. We have to send a copy of the subpoena with the notice of intent to all the other parties. Otherwise, they would not know what to object to if they didn't actually see the subpoena. Third document, the certificate prerequisite. This is the document that has the four numbered paragraphs that basically just confirm that we did the notice of intent, we served it on all the other parties, we sent them all a copy of the subpoena, we gave them 20 days to object, and they did not object. So it's just the statement verifying that we did what we were supposed to do under the rules. And then the fourth document is the notice and certificate of compliance, which we draft and send with the subpoena to the non-party. And ideally, the non-party then signs the certificate and sends it back with the documents in response to the subpoena. So looking at the rules a little more specifically that deal with all of this. Rule 4009.21, this is a rule that requires that we have to give every other party at least 20 days before serving the subpoena. And that if a party wants to object within those 20 days, they can do so, but they must do it in writing and they must serve it on all the parties. So if you're going to object, you have to do it in writing and you have to send it to all the parties, not just the parties who want to serve the subpoena, but to all the parties. If the objection is served back on all the parties within 20 days, the subpoena cannot be served until the issue is resolved. Okay, so if the objection is served within 20 days, subpoena cannot be served until the issue is resolved. If the 20 days have passed and a party objects late, the subpoena can be served on the non-party. At that point, the burden is on the party who objected late to file a motion for a protective order with the court to try to prevent the subpoena from being served. Okay, so let me say that again. If the objection is served within 20 days, no problem. Don't serve the subpoena. Issue has to be resolved. Very clear. If the objection is served after 20 days and the subpoena has not been served yet, the subpoena can still be served, okay? Because the 20 days are up, subpoena can be served. The party who is objecting has the right, if they want to pursue it, to file a motion for protective order in court to try to prevent the subpoena from being served. But the burden at that point is on the party objecting because they have objected late. The next rule that deals with this is 4009.22. Again, should sound very familiar. The party may serve the subpoena if identical to the one sent with the notice of intent to serve the other party. So basically, we've done the notice of intent. We let all the other parties see the subpoena. 20 days have passed. We can now serve the subpoena, assuming it is identical to the one we provided to the parties. Okay. And as long as we file the certificate prerequisite stating that we served the notice of intent, we gave them 20 days, there were no objections, and we have served, and we have included a copy of the notice of intent to the certificate prerequisite. Okay, so again, it sounds so repetitive, and it really is, but I just want to make sure you really understand it, so I'm going to say it again. We've served the notice of intent with the subpoena. 20 days have passed. Okay, we can now serve the subpoena. We also have to draft the certificate prerequisite. And the certificate prerequisite is going to state that we have served this on all the other parties. They've had 20 days. There are no objections. We're going to attach a copy of the notice of intent to the certificate prerequisite, and we're going to file that with the court. And so the court knows. So normally you take that in the same time you go and get the subpoena certified by the Prothonotari's office. Okay. Then the next rule deals with the last document, Rule 4009.23. We're going to draft the certificate of compliance, send it to the non-party. The non-party then should execute it, meaning sign it and send it back to us with the documents that we have requested. Okay. Once we receive the documents back from the non-party, we then have to give notice to all the other parties that we have received the documents. Okay. There's no formal process or form to use, but the rules do state that we shall give notice of receipt of the documents we requested to all the other parties in the case. And if the other parties request it and pay a reasonable cost for copying, we need to furnish copies of those documents to all the other parties. Okay. But they have to request it and they have to pay a reasonable copying cost. So if they do that, then we have to furnish those copies to everyone. Okay. So those are, again, the 4 documents. So there they are again. Those are the 4 documents you're doing for your assignment. Just understand what they are, know them by at least the short-term names, notice of intent, the subpoena, the certificate prerequisite, the certificate of compliance, and be clear on what they are and their purpose and kind of how they interact with each other. Okay. So some practical considerations when we're dealing with requests for production of documents. And these considerations are true of both parties and non-party requests. Okay, so now we're dealing with party and non-party requests. Okay, so one, I mentioned this in class, the amount of documents requested. So we're going to request documents that are relevant to our case. And if they do exist, these are the documents that we want. Just keeping in mind, once we get them back, there can be significant work involved. Somebody has to review them, organize, index them, see what's in there, see what relevant information we need to follow up on, see what information helps us with our claim or defense. So it's not just getting the documents, it's actually looking at them. Also, the concept of bait stamping, if you haven't heard that before. We don't necessarily stamp them so much anymore because they either come in electronic format or we upload them. But the bait stamp used to be an actual stamp where you could, like for instance, have it list document 1, page 1 of 20, page 2 of 20, page 3 of 20. And you literally would sit there with the pile of documents, stamp one page, move it, stamp the next page, move it, stamp the third page, and on and on and on. So every page was basically labeled and accounted for. The best thing about bait stamp that people would talk about is if you were having a bad day, it was a great way to take out aggressions because you could just stamp hard on all those documents. Even if you are not physically doing the bait stamp, when we upload these documents into our case file database or when we just save them electronically into the database, we still have to look through these documents. We still have to organize them. There's no guarantee they're coming from the sender in an order that is organized for us. And so this is where it takes some time. And depending on the type of litigation, you might be looking at 30 documents. You might be looking at thousands of documents. So it can take a while. This is where the cost will go up to the client because we would be usually charging the client for the time we're spending on this. And so it's not a deterrent to request relevant documents, but it definitely is a consideration. Don't get too ambitious in your request. You always want to stay relevant and you want to basically ask for what you want if it exists. Okay, always keep in mind, we don't always know what documents actually exist, what photographs actually exist, what information is out there. but we want to phrase our request in a way that if this information exists, we are requesting it and we will actually receive it. Additionally, with the electronic discovery, there are some additional concerns or factors, and some of these we have already talked about, but it's relevant to the document request, so I want to review them. One is, where are these documents? Where is this electronically stored information? Is this information we can easily gather ourselves? Is this information we have to bring in IT experts, or is it something that we have to bring in forensic computer specialists to draft codes, to write codes, to access it? And depending what kind of documentation it is, it may not all be stored in the same place. For instance, where the emails are stored on the server may be different than where your research and development information is, or reports are kept and that type of thing. So we do have to make sure we are accessing all the places where the information is likely to be. Also, already talked about the cost associated with it. If it's information that's easy for us to get, the cost will be minimal, but we do have to think about that cost. And also be aware, as we've already talked about, the fact that sometimes that cost can be shifted. And so if we have spent, $30,000 on e-discovery costs to find information, and we're successful on the case, we may ask the court to order the other party to pay us, and the reverse is also true. If the other side has had to incur costs, we may end up having to pay them for those costs. If the court views it as modern day copying cost equivalent, that may be something that we have to prepare to pay one way or the other. So it is also something to keep in mind. Remember litigation hold policies, making sure those policies are in place and that we advise our clients to put the litigation policy in effect when it needs to be. And then the spoliation issue, we have to be very careful with that, making sure the documents are not changed in any way. These are very fact-sensitive cases, the cases that deal with spoliation. There was a recent Third Circuit case that dealt, it was a UPS case. And the court held there that producing copies in instances where the originals have been requested may constitute spoliation if it would prevent discovering critical information. And so basically we have a case where in this particular instance, they didn't find that that happened, but we have a Third Circuit case and we're sitting in the Third Circuit that if party requests an original and we send them a copy, that might be considered spoliation if there's information in that original. And so again, that's kind of the native versus the non-native format. That can certainly be an issue. And in this particular case with UPS, there were also some questions of the attorney's honesty in dealing with the request. But the court noted when you're dealing with electronically stored information, the concept of an original document becomes much more abstract as technology changes. So that means the concept of spoliation also changes as the technology changes. And it's something we just have to be very aware of and make sure that we're advising our clients appropriately.